Hi, this is Tyler and Douglas Gabriel, and we're here today with Michael McKibben, but I'm speaking today with my Betsy hat on because I am really upset with what I have just read and what it's taken me a while to understand. Michael McKibben has been telling us for quite some time that it's okay, it's legal to lie to Congress. And he says that, and of course, in my head, I go, yeah, they all lie, nothing ever gets done, and on and on and on, and it wasn't really sinking in. And then we were working on some, with these Mueller investigations and with the different testimonies that are going on, we just don't see any traction. People are just lying everywhere, nothing's happening to them. And last night, Michael sent me something for posting on Truth News Headlines, and as I was reading it, I got this aha moment that, oh my gosh, Michael isn't kidding. Do you know people, and you ought to be extremely outraged about this, that they can sit in Congress and they can lie to everybody in there, to us, to the people that are questioning them. The people questioning can lie. They can all lie, and it's legal. And Michael is going to tell you why, and I hope you get as upset as I am. Now, we're going to be talking about a lot of things that you'll want to look at yourself, and I've included those in the link that's in your description box. Michael, tell me, why is it legal?
Because on, let me get the date right, on October 11th of 1996, Congress passed the False Statements Accountability Act, FSAA, and it was the update of a much earlier law that reached back to in the 1930s, and essentially that law said what we would expect it to say, that it's illegal to lie to Congress, to make false statements. And in fact, if you read the current version of the act, that's the way it reads in subsection A, which is 18 U.S.C. 1001. And subsection A says, except as otherwise provided in this section, whoever in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States knowingly and willfully, A, or 1, falsifies, conceals, or covers up by any trick, scheme, or device a material fact, 2, makes any materially false, fictitious, or fraudulent statement or representation, or 3, makes or uses any false writing or document knowing the same to contain any materially false, fictitious, or fraudulent statement or entry, shall be fined, now there's other words in there, but shall be fined under this title, imprisoned not more than 5 years, or if the offense involves international or domestic terrorism, as defined in Section 2331, imprisoned not more than 8 years, or both. That's subsection A. And I've always...
All right, so in that section, they do tell you what the liabilities for lying are, right?
Correct.
Okay, so
that's subsection A.
Because that's subsection A, folks. And so most people, as Michael points out, they read the A and then they go, okay, well, there you go. But there's the fine print.
Yes. Now let's go to subsection B. Nice lawyer trick. Subsection B says, subsection A does not apply to a party to a judicial proceeding or that party's counsel, writings, or documents submitted by such party or counsel to a judge or magistrate in that proceeding. It doesn't apply.
Okay. All right, wait a minute. Let's take someone like Paul Manafort. And Douglas, you're on the phone, or even someone like Roger Stone. How does this apply to them?
It totally applies to them. It says they can lie too. In other words, it's legal for anybody in any judicial proceeding in any of the branches of government, which is anytime you're before a tribunal, administrative court, a judge, at any level. This says, subsection B says, you can lie because subsection A doesn't apply if you're before that judicial proceeding. This is the most egregious sleight of hand, I think, that Congress has ever passed. And by the way, this was passed, as a point of fact, on the same day that the Economic Espionage Act was passed on October 11th, 1996, unanimously. That happened to have been written by my former patent attorney, James P. Chandler III. He used to boast about how Congress passed his Economic Espionage Act without a single dissenting vote. what I never knew until I was doing some collecting data from Congress on the Economic Espionage Act, that this other act was passed on the same day, and it has this very devious title, the False Statements Accountability Act. And what it needs to add there, in my view, is the word sucker. Because we have all been suckered into thinking Congress is protecting our interests as citizens by insisting that people tell the truth when they're working with our government. But in fact, what they have done is they exempted everyone, including all of the Congress people, all of their staff, all the people testifying before them, all the lawyers involved, and they've said you can lie because subsection A doesn't apply.
Well, immediately people are going to think about the Benghazi testimonies. That was all lies. We knew it was lies.
They're never going to. They cannot be held accountable to it because this is their get-out-of-jail-free card. If anybody tries to prosecute them, and this was my thought about Roger. Roger should use this. Roger Stone, because clearly it's saying they're accusing him of lying to the congressional committee. But and most of those claims against him. But the fact is, that committee itself has already exempted itself from all lies that they tell, and they've exempted themselves from all lies that people tell to them, to a party, to a judicial proceeding, which would be testimony to Congress. I mean, it's just outrageous.
So taxpayers, this is what you're paying for. They've allowed themselves to lie to us, to each other, to anything. It is truly a den of vipers.
Now, people are not going to believe this, I'm sure, because I wouldn't believe it if I heard it for the first time. But look it up. It's 18 U.S.C. 1001. Read both subsections, subsection A and subsection B. Now, one of the ways you kind of verify, because the first time I read it, I said this can't be true. Has this ever been interpreted? Has this ever been challenged? And the answer is yes. It has been challenged, and there have been several key opinions that were passed in the appeals courts to justify and verify that, in fact, it is legal to lie. And by the way, for those of you who follow Betsy and Thomas, this is in the Ninth Circuit. So a judge by the name of Susan P. Graber has written opinions verifying that Congress indeed said it is possible to lie. Let me read you one of them. Some of her quotes in U.S. versus McNeil. This was in 2004 in the Ninth Circuit. The amended version of 18 U.S.C. 1001 is unambiguous on its face. Statements made in judicial proceedings are excluded from liability under the statute by subsection B. There you go. That's pretty clear. Now, in U.S. v. Horvath in 2007 in the Ninth Circuit, this is at paragraph 1081. Judge Graber wrote, "Our only task to understand what Congress meant when it chose to exempt from criminal liability certain kinds of lies to the federal government. Under 18 U.S.C. 1001B, which is subsection B, criminal liability does not attach to materially false statements submitted by a party to a judge in a judicial proceeding," which would include, by the way, all this testimony to Congress, "even if the party makes the statements knowingly and willfully." So
takes my breath
it has
away.
been affirmed by precedent.
Well, Michael, you've pointed this out many times in many audios, and what is just kind of despicable about the whole thing is that this is why they act with impunity. This is why Comey perjured himself 3 times and he didn't think anything about it and he wasn't prosecuted. This is why Andrew McCabe, who is a massive perjurer and leaker, is only being investigated for a lack of candor. But if you or I perjured ourselves, well, then we could go to jail, especially if they wished to.
No, Douglas, you're not getting it. Sorry. I'm just being dramatic.
Well, but that's true.
We can lie too by this law.
It's just that we didn't know about it. The regular people out here don't know about it. They kept it to themselves.
But as you pointed out, it's been used very seldom, and certainly it's never been used for anyone but the elite.
That's probably the truth. But the fact is, this protects anybody that's giving testimony. Protects Roger Stone. It protects anybody giving testimony. Not when I say protect, it prevents any liability for their lies. Now, is it moral? No, but that's not the point.
Well, we know these people are not
they,
moral. We saw what they want to do with babies that are just being born. So, of course, they made it legal to lie. So this means that from this point on, if you hear our broadcast and you look at those laws yourself, you will know that everything that comes out of their mouths could be a lie.
And as you were saying earlier in our conversation, the recourse is that it doesn't really matter whether it's in a public statement or whatever. If it goes to a judicial hearing of any type, then they have this as their backdoor, their way of getting out.
Right, but the people have to realize that judicial is confusing, because that sounds like a court, like a district court. No, this is any proceeding, administrative or otherwise, before the U.S. government. Subsection A, I'll read again. Whoever in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government. That's who that applies to. These are the proceedings that this is applied to, which executive, legislative, and judicial is all three branches of government. So this is covering everybody about everything. Now, do they prosecute people and put people in jail over subsection A? Yeah, but for the life of me, I don't understand why these attorneys would allow that to happen, knowing that subsection B is there. So they must be sacrificing a lot of people to the wolves as a result, because subsection B gets them out of it.
But we don't follow these things that closely. If they send somebody off to prison or jail, we're not there. We don't have reporters on the ground to see if they're actually there. They could be walking in one door and walking out the other and going to Puerto Rico for the 3 years they're supposed to be off the scene.
Well,
I mean, in a culture of lying, what can we believe anymore?
Well, we've got to rescind this law. It's one of the things we have to do.
Well, this law is the foundation.
This is on the books. Congress passed this.
Sure. Well, because it covers their rear. Now, did you say?
By the way, sorry to interrupt you, Douglas, but this was going on in 1996. This is when the Highlands Group was getting organized with all the mass surveillance. So this was passed on the very same day that the Economic Espionage Act was passed. And what we now know from 1993, when Clinton came to power, through the end of that time period to about 2000, they were getting their ducks in a row legally for the big takedown in the Patriot Act. So these were some of the steps that they took. So I am sure I can hear this argument now to Congress. Well, when we're asked about state secrets or things that could harm the American government, we can't necessarily tell the truth if asked before Congress. So therefore, we need the ability to lie without liability. I'm sure that's the argument.
But they're the very people that are doing it to us. These are the people that need to come and be truthful, because what they're trying to hide is not something that's so sensitive that would protect the American people. It's something so egregious that shows their traitorous plan.
Remember that intelligence agreement that was signed in 1946 that began the Five Eyes. So the Americans, Brits, in New Zealand, in Canada, and Australia all agreed to share all their intelligence all the time. So with that, and they agreed to keep that agreement secret. So if they were ever asked by a congressman, does that exist, that congressperson would be violating that agreement by saying it existed, so they're going to lie and say it didn't exist. So there you have it. You're right, Betsy. We are getting hosed by the same group of people that we've been talking about now that's had about 100 years of getting organized, and this was another step.
Well, it's basically the same old Jesuit tricks. The Jesuits were allowed to lie, steal, espionage, subterfuge, whatever it took, and even kill, and they were pre-forgiven. So it didn't matter. They could do whatever they wanted. And this is basically the justification for the impunity upon which federalists, these people in our federal government, act, and they realize they're not going to get caught, they're not going to get prosecuted, because If they know this law, then they know they can get out of it. Previously, they always used national security. Oh, it's national security. We can't even tell the president because it's a counterintelligence operation, and we can lie about it. Anybody in the CIA, their first job is to be liars, right? That's what they do. They are basically our Jesuits. They go out, they lie, they sneak around, they try to infiltrate, they use their subterfuge, all this stuff. And that's for national security purposes. But now it doesn't even matter. But my question to you is, did you say, and I thought you did, that this applies specifically to federal judiciary?
It's executive, legislative, and judicial branches.
So so then it would be federal. It's not going to. Would this apply in state courts?
I don't know.
Yeah, I think it wouldn't, from what you've read us and what you've told us in the past. And so my only point is that this is how the federal government that we watch every day on the news, and we watch them lie. It's just.
Well, I'm reading it now. In any matter within the jurisdiction of the executive, legislative, and judicial branch of the government of the United States. So I would guess that state government doesn't necessarily apply unless there's some cross-jurisdiction issue. I would guess. I don't know.
Now, I can see some of the logic, especially following upon the Espionage Act, that they want to say to some senator who's on the Intelligence Committee that if he's asked a question in testimony before Congress, that he would be able to defer by even lying if necessary because he can't reveal the truth. I think that needs to end. I think all these things of lack of transparency need to end, in my opinion.
Remember Clapper when he was asked by Senator Wyden?
Oh, yeah.
If the NSA spied on all Americans, and he said, remember how he hesitated? My bet is subsection B flashed through his head. And then he said, no.
That's funny. Well, he's not been prosecuted for his lack of candor, for his perjury, for his lies, for his false testimony. So, you got to wonder why. And then when you think, oh, all the federal people all know this, and they basically are all covering each other's rears because they know they can simply, if they get dragged into a court, they'll just make it a federal court, and they can.
Well, this law was around when Clinton was put up on impeachment charges, and then all of a sudden that was dropped, wasn't it?
Wow, that's rather interesting because he lied. That his crime was not that he had the affair, but that he lied, and literally the lack of candor. And in the end, the definition of the word is. And it was that lying that got him in trouble. So, lying is the number one thing going on in the politicalized DOJ and FBI, as we saw. It's just lying and leaking and lying about the leaking and leaking about the lying. And, oh, my goodness.
Well, here's the other thing. With this law in place, you almost want to get in front of a tribunal and lie because then that covers you. This subsection B covers you. So, ask me to come before Congress. I'll lie.
But this is why we see all the time these perjury charges. We know it's treason what they've done, but they say, he'll be James Baker, one count of perjury. And you're going, really? That's it? Well, that's because, okay, we charged them, and now we're going to go behind closed doors and give him absolution, right? That's what they do. And so
they don't have to do it behind closed doors. They do it
behind closed doors because they don't want the rest of us to know that it's legal to lie to them. So they save that little goodie for themselves. That's how egregious this is. But then you take everybody that's come in front of this Mueller investigation. Tell me, does this apply to them?
Yes.
How about Concord Catering?
Everything that happens in the U.S. government, period. It's all three branches.
Okay.
No, you're right to be upset, Betsy, because in the grand jury, kangaroo court, they get them by entrapment by saying they lied. But in other courts, like the grand jury indictment for Andrew McCabe, no one even gets to hear anything about that, and they call it lack of candor instead of lying, instead of these process crimes, which they lied to the grand jury.
These guys all know that this subsection B is out there. They know they're covered. That's why they're so arrogant, I think. They know it. This is their dark little secret. I won't tell you which congressman I pointed this out to, but he didn't know it. He didn't know about it. And my bet is this is so widely known among the corruptocrats that they don't want other people to know about it because it's so darned embarrassing. This is so immoral. And they know that the American public doesn't believes that subsection A is the operative language, not subsection B. They probably never even read it.
Well, it's a beautiful thing for a Federalist. It's a beautiful thing for the senior executive service members. It's a beautiful thing for the White House. It's a beautiful thing for anybody who knows in D.C., in the District of Crime, that this exists. It is their get-out-of-jail-free card. And it's really very, very disturbing to hear it, and just to know that that kind of thinking goes on. And the justification that we've mentioned, for national security issues or for espionage or this or that, that doesn't wash. I need a perfectly transparent government. I need an FBI that doesn't do deals by giving immunity to star witnesses like James Comey, that then he was the criminal. I don't need the FBI doing entrapment on other criminals who didn't have the drugs or didn't have the money until the FBI entrapped them. And I don't like the fact that they can make these capricious determinations about justice which abnegate justice. And what we have here is the perfect abnegation of all justice, so that federalism literally is as bad as so many people say it is, particularly in the past. The feds know that they can lie. That's the beautiful explanation of why we get nothing but lies from the feds.
Well, it's worse than that, Douglas, because this also says the people talking to the liars can lie.
Yeah, and their lawyers can lie. And
their lawyers can lie.
Yes.
And they can give false testimony. And they can give false documents. They can give fabricated documents. It doesn't matter. They can delete documents. It doesn't matter.
Well,
Subsection B says they're not liable.
This underscores what we have been harping on, which is fake justice. This is the worst kind of fake justice imaginable, that the elites in the federal government, kind of like the monarchy and the landed gentry, they are not held accountable to the same laws that we are. And if you don't happen to have the right clever legal representation who knows this law exists, then you cannot use it, or you won't use it because you don't know it exists. But those who do know it exists, they don't even get called into court because the court knows that these Federalists know that they can get out of it. It's a waste of time. I mean, this is a setup.
If somebody here's the trick. The tribunals that people testify to, they presumably know this law exists. But the rule is they don't give legal advice to the people before them. So if somebody cites subsection A and their lawyer doesn't protect them with subsection B, then there's no requirement by the judge in that case to remind the person about subsection B. So they can get prosecuted on subsection A, and then if that guy's lawyer isn't smart enough to use subsection B, the judge doesn't have any recourse except to prosecute them on subsection A only. That's the trick here. Wow.
Well, legal chicanery and legal tricks just make me sick. But I am sure glad that Betsy got upset about this and made sure that we got a clarification on this, because the clarification makes it worse than even what I thought it was in the last 2 years that we've been thinking about this particular law that you've brought forward, that when you hear about it, you just think, yes, this is the kind of legalese that causes you to just be completely frustrated anytime you go to court. But especially if you get called into a federal court, you just don't have a chance. We, the people, the commoners, do not do well in federal courts, and this is just a perfect reason why. So,
but we can now, because we can cite this law just as well as the bad guys can, until this law gets rescinded, which it has to get rescinded.
Well, Michael, again, your research and the research of your helpers and the people at Americans for Innovation, It's just astounding. So we have to thank you again for bringing this to light, and thank Betsy for making sure that we talked about this today, and thank her for getting a little bit worked up about it, because really this is something that we should get worked up about. This is the basis
Absolutely.
of impunity for those criminals in the district of crime. And it's about time, as you said, that we revisit this particular law and basically throw it out and take away that get out of jail card from all of the Federalists. And that would be a beautiful thing, the day that the foundation of falsehood politics and the post-truth age is right there in front of us. And so thank you again for bringing this to light. And
Well, we thank our team too.
oh, absolutely, the amount of research that's done by all of your researchers is just astounding. So thank you for this report today, and thank you, Betsy, and
You're welcome.
we will talk again soon.